advocated list.
Thanks.
The only thing that's new, my lord, it's at number 87 on page 7.
87.
Yes. Number 87 on page 7.
Okay.
Exhibit XX.
Yeah.
That's the SAP 310 form
Okay.
regarding interview with the suspect. It's a form that was handed by Advocate Nisi.
It was handed to you by Mr. Mnisi.
Yes.
Right.
At the request of Advocate Nisi.
He says he wants to use it.
Yeah, well, he requested that it be handed up. I suppose he's going to be fair.
Oh, he'll explain.
Yeah,
Okay, fine.
at some later stage.
All right.
Then number 88 on page 8.
Yes.
It's Exhibit YY.
Right.
This is a letter from Legal Practice Council dated 5 May 2020 confirming the enrollment of Mr. Dominic Ntokozo Mjiako as a legal practitioner, which was received by Brigadier Gininda from Mr. Mjiako at Pretoria North Police Station
Yeah.
on the 23rd of June 2020.
Okay.
It was handed up via Brigadier Gininda.
Gininda. Okay.
The third thing, my lord, when we adjourned the proceedings,
Yeah.
Brigadier Gininda was under cross-examination by Advocate Ngumezulu, and the further cross-examination stood down at the request of Advocate Ngumezulu.
Okay.
Mshushisidana bekachaza ukuthi kunamaphepha asanda kwakhona ukuthi kunezinto ezithize ezishintshile la ukuthi kunobufakazi buka XX kuneform eyukuthi bekade kukhulunywa nabamangalelwa bese kuba nobufakazi buka YY ekuyincwadi eyukuthi yasho ukuthi uDominic Ntokozo Mjiako ngempela ungummeli eyukuthi basazokhuluma nangayo. Enye into futhi uma sigcina nyakenye ummeli umnumzana Ngomezulu wayekade esabuza uBrigadier Gininda imibuzo uzoqhubeka kusukela lapho.
Okay, where is the brigadier?
It's just outside.
Oh, okay. For record purposes, Mr. Ngumezulu, have you recovered or recuperated from your ailments?
That is correct, my lord.
Okay.
I am fit emotionally, physically, and
Okay.
thanks.
Thanks. Right. For record purposes, Brigadier, yeah, do you swear that the further evidence you're going to give will also be the truth and nothing else but the truth? Okay.
Uthi usazokhuluma iqiniso uBrigadier uyaqhubeka kusukela lapho khona.
Yes, Mr. Ngumezulu.
God bless us, my lord. Mr. Gininda, on the last occasion, I was asking about the J50s, the warrants of arrest. Do you still remember that?
Yes, I do remember that you spoke about the warrant of arrest of accused 1 and 2.
Usakhumbula umnumzana uGininda ukuthi bekukhulunywa ngephepha eligunyaza ukuboshwa umangalo lokuqala nowesibini.
Just want to establish, are you aware that that application is governed by Section 43 of the Criminal Procedure Act?
Yes, the application for the J50 warrants I am aware.
Uthi uyazi ukuthi umthethosekelo owabekwa lapho uyilo ukuthi wakhishwa ogunyazayo ukuthi abamangalelwa bangakhishelwa lezo incwadi uyazi ngawo.
Was the applicant brought by yourself or by the state prosecutor?
I've explained, my lord, that there was an indictment. After the indictment, I then made an application in the persona affidavit to the Toksvik Magistrate Court. based on the indictment by the North Gauteng PPP.
chazile ukuthi kwakukade kunencwadi eyikuthi bekade iphuma kuba kumphathi wabashushisi yena ke wayenza i-affidavit.
This affidavit was, it's common, it's clear that it is in support of the application for the warrants of arrest.
It is for the application for the 50s mandate for accused 1 up to 5.
I-affidavit leyo bekade vele ihambiselana nalezo incwadi ezigunyazwa ukuboshwa bonke abamangalelwa kusukela kowokuqala ukuya kowesihlanu.
So it is your evidence that all 5 accused before this honorable court were arrested on the strength of the warrant of arrest.
Yes, it is.
Bonke abamangalelwa bona baboshwa ngenxa yokuthi bekade kukhishwe leyo ncwadi egunyazayo ukuthi baboshwe.
When looking at the provisions of section 43, it relates to an application to be brought before a magistrate. And such application is to be brought before the magistrate at which the alleged offense was committed. Do you agree?
I do agree, my lord.
Yavuma ukuthi incwadi lezo zona ezigunyazayo kwamele zikhishwe la ukuthi kusendaweni noma esivininini sala icala lenzakele ngakhona.
So in this case, 636 of 10/2014, it's common cause that it occurred in forced lockers.
Yes,
Correct.
it is. That is correct, my lord.
Iqiniso ukuthi lelicala le 636 10 of 2014 lona liyenzakele eForce Lorals.
And we also have courts in forced lockers.
Yes, we do. But Boxbeck, my lord, is a
I'm sorry, sir.
Oh.
Can I please, we are not in a lecture room. Follow my question, because there are technical issues that I'm coming to raise here. I'm saying it's common cause that this alleged offense or this offense was committed in forced lockers. Is that so?
My lord, I've agreed with that, but it will be trying to mislead this court to try and create an impression that Boxbeck does not fall within the jurisdiction of forced arrest. That's what I wanted to clarify, and I think Mr. Mgomezulu knows that. Boxbeck, forced arrest is a district court. In Boxbeck, you get the regional court. Within the district of that area, it's one district, my lord. So there's nothing peculiar or unlawful that was done there.
Kuthi-ke ummeli lelicala leli kuyazeka ukuthi liyenzakele eForce Lorals futhi eForce Lorals kuney'nkantolo.
I'm going
Uma
to,
ichaza-ke ubrigadiri uthi yena yebo zikhona kodwa nkosi enkantolo ngicela ukucacisa lana ukuthi eForce Lorals kuney'nkantolo ezingaphansi ama-district court bese iBoxbeck nayo iwela khona ngale ngaseForce Lorals kula uthola-ke ama-regional courts.
do you know the rules relating to demarcation
My
in
lord,
terms of jurisdictions?
That's a good place, my lord. We don't want to interfere with my learned friend's cross-examination, but we don't see the relevance of this question. The issue of demarcation of jurisdiction has got absolutely nothing to do with this witness.
Yes, Mr. Mgomezulu, where are you going to?
I'm going to the place where this application was brought.
But we are in the High Court.
I beg your pardon.
Unless you want to submit that this case was unlawfully transferred from the regional court to the High Court.
That's not
pursuant to section 72C, if you want to allege that. But now we are in the High Court.
No, I'm not
Oh, I see. Okay,
I'm not
fine.
relating to that. The sequence of my question relates with section 43, and it must be understood by these accused persons that are before this honorable court to say, when I'm dealing with the issue of jurisdiction, I'll just demonstrate to the court that this application has been brought before a wrong court.
Okay, fine. What's your view?
I disagree, my lord. It's the same jurisdiction. I think the understanding of Mr. Mngomezulu is absolutely wrong.
Okay.
umnumzana uNgomezulu uthi bekafuna ukubonisa ukuthi lesiya sicelo besifakwe endaweni ekungasiyona uthi ubrigadier uyala uthi yena akaboni ukuthi bekafake lesiya sicelo endaweni ekungasiyona.
I'll leave that for argument, but still maintain that Foslorus Court, the magistrate of Foslorus Court, as per section 43, directing that this person should be brought before a lower court. It was referring to Foslorus Court when the offense was committed.
It's the same jurisdiction, my lord. That's the point that I'm saying. That's why the SPP in Boksburg also is the same SPP for Foslorus District Court. There's one SPP, including the control prosecutor. So it's one and the same, my lord.
Uthi-ke manje mina ngiyafuna ukukwazisa ukuthi wena lesiya sicelo usifake endaweni ekungasiyona ngoba bekwamele icala njengoba lenzakele eFoslorus bekwamele abamangalelwa bayobulisa umantshi ngale eFoslorus uthi indawo efanayo ngoba umphathi ophethe abashushisi owase-Boksburg uyena ophethe abashushisi baseFoslorus manje ukuya ngayo ubrigadier uthi indawo efanayo.
I'm glad I have authority to the proposition that I've just put to you, which I'll reserve it for argument. May I proceed? Let's get into the requirement that a peace officer or the commissioned officer who is to execute the warrant, when bringing this application, must have a reasonable suspicion that a particular offense has been committed. Are you aware of that?
Yes, I'm aware. This is the application now for the warrant of arrest, the J50.
I'm talking about the warrant of arrest.
Yes.
J50,
Yes.
section 43.
Yes.
Uthi uyazi nawo ukuthi umuntu womthetho uma yena efaka isicelo sayo lencwadi le egunyaza ukuboshwa komuntu kwamele abe nokusola okuthize ukuthi kunecala elithize elenzakela uthi yebo ngiyazi.
And in terms of your evidence, you brought this application in October 2020, correct?
23 of October 2020, that's correct, my lord.
Uthi ukuya ngobufakazi bakho wena uthe lesicelo usifake ngo-October 2020 uthi yebo nge-23 zika-October 2020.
And I'm referring to all 5 accused were already in custody when you brought this application, correct?
Yeah, but my lord, I think we dealt with this aspect. I think it must be clear that they were in custody for different matters. To try and create an impression that they were in custody for this matter.
Mr. Kininda, sorry sir, with due respect, I'm not creating any impression. I'm cross-examining you on what is prescribed by the law. I'm not giving my opinion here. What I'm saying is, when you approach the court, Boksburg Court, on the 23rd of October 2023, I didn't want to know the reason as to why were they arrested, who was arrested first. I was saying all 5 accused were already arrested, they were in custody. Is that so?
For different matters, yes, my lord.
Uthi manje uyavumelana nami ukuthi ngalesikhathi ufaka lesicelo nge-23 zika-October 2020 bonke abamangalelwa akunandaba ukuthi bekade beboshelweni kodwa bonke abamangalelwa bona bebakade beboshiwe uthi yebo bebaboshiwe kodwa baboshelwa amacala angafani kungasiyileli cala.
Correct. The application that you brought on the 23rd of October 2020, if you understand what is a warrant of arrest, it talks about depriving somebody of his liberty. Do you agree?
My lord,
As a court case, my lord, we just want to, the insinuation that if a brigadier knows something about a warrant, I think that we find that belittling and should be withdrawn.
Now, I differ with my colleague. Brigadier Kininda is a very experienced police officer. The reason why I ask about Section 43, you can't do things because you have done it and you don't do it according to what the law prescribes.
Sorry.
If I'm talking, my lord, may I address it further before you?
Oh, okay, fine. Fine.
With due respect.
No, it's okay.
When this application was brought, if the brigadier was at that time able to distinguish between how warrants are issued and to him, when he brought this application, he was fully aware, because this is what the provisions of Section 43 and the case law requires, that he must exercise an independent opinion. Hence, his capabilities are expected when bringing this application. I cannot bring bail application not knowing what are the tests for bail application, what are the reasons for the refusal of bail, or what would be the reasons for granting bail. My submission is that in terms of what is required by this provision, especially case law, in Maposa's case, it reiterates the aspect of an independent opinion to be exercised by who? By the commission officer who's executing a warrant of arrest in terms of Section 44 of the Criminal Procedure Act. He must answer questions relating to this application that he brought for the arrest of these people.
Yeah, but I'm not interfering. Mr. Brigadier Ginenda says you and him have a different conceptual understanding of Section 43. Is that correct?
that's correct, my lord.
Let's read Section 43.
Thank you.
Because he says you don't have the understanding which he has.
Let's read. Can you
So
read it for me?
who's got Section 43?
manje ke uma kuchazwa kuthiwa ingathi ummeli nobrigadier banokuzwisisa okuhlukile ngaleyo mthetho-sekelo okukhulunywa ngawo waka-43 oyikuthi
There's no subsection you want. You just want Section 43 section.
uya ngobrigadier yena uwazi kanje
Hello?
Subsection one.
umnumzana uwazi kanje
Section 43, subsection 1.
Correct.
Mr. Council is going to read it out.
Not me.
I'll read it out. The heading is warrant of arrest may be issued by magistrate or justice. Subsection 1 of Section 43. Any magistrate or justice may issue a warrant for the arrest of any person upon the written application of an Attorney General, now Director of Public Prosecutions, a public prosecutor or commissioned officer of police, then subsection A, which sets out the offense alleged to have been committed, subsection B, which alleges that such offense was committed within the area of jurisdiction of such magistrate, or in the case of a justice, within the area of jurisdiction of the magistrate within whose district or area application is made to the justice for such warrant, or where such offense was not committed within such area of jurisdiction, which alleges that the person in respect of whom the application is made is known or is on reasonable grounds suspected to be within such area of jurisdiction, and subsection C, which state that from information taken upon oath there is a reasonable suspicion that the person in respect of whom the warrant is applied for has committed the alleged offense. Subsection 1 in capital A. Notwithstanding any other law, an application for a warrant under this section in respect of the offenses listed in section 21 in brackets 1A, A to D, may be made to any magistrate or justice, irrespective of whether or not the place of execution of the warrant or the place where the alleged crime has been committed falls within the jurisdiction of such a magistrate or justice. Subsection 2. A warrant of arrest issued under this section shall direct that the person described in the warrant shall be arrested by a peace officer in respect of the offense set out in the warrant, and that he be brought before a lower court in accordance with the provisions of section 50. And lastly, subsection 3. A warrant of arrest may be issued on any day and shall remain in force until it is cancelled by the person who issued it, or if such a person is not available, by any person with like authority, or until it is executed.
Thank you.
Now, what is the problem?
The the question from the court, I just want to get it clear. If does it relate, the question of the court, does it relate
Now it relates
to the
both-
difference between,
It relates to both of you. Because
both of
me
us.
listening to this section being read, there is no problem. It's clear as water. What should happen?
it is clear.
So what are you saying Brigadier Ginenda did not do in pursuance of section 43, subsection 1? What did he not do?
All
So
right.
that we all know the
Okay.
dispute.
If I'm understood very well,
Yeah.
because I'm trying to run away from the fact that a witness will say, I'm creating an impression. Let's just put it straight and clear forward. Warrant of arrest, it deals with somebody who is not in custody.
No, that's not how I understand the law. I kill somebody today, and Inspector Nisi arrests me and puts me in custody because he's got evidence that I killed somebody. After 3 weeks, Inspector Nisi hears that, he killed another one in Klipspruit. I'm inside. He goes and effects a warrant of arrest in respect of that other one. What's the problem?
My Lord, I'll differ with the court.
Okay,
I'll
fine.
differ with the court. I'll make submissions as well.
Okay.
Because there is also a procedure in relation to the requisitioning of a particular suspect or an accused person. Yes. Hence, a scenario in terms of what the court is now making, it's relating to it actually goes to the meaning of what is arrest. It will actually go to the meaning of what is arrest, because the logic on this application, because there's somewhere in this provision that says a person is reasonably suspected to be residing somewhere, if I'm not mistaken. But when an application is brought by an officer who is fully aware that this person is not in Tembisa, this person is Modapi, it's clearly misrepresentation of facts, because If you look at the J50 that we talk about, it does not bear the date, the address in which the suspect is at the time of the application was brought. That's the reason why I'm
So you're
saying.
saying Brigadier Ginenda didn't specify where the suspect,
That's correct.
that they are in Moda B, as you say.
That's correct.
Sir, what specificity did you annotate on the warrant?
My lord, insofar as accused 1 and 2, well, let me start with 1, my lord.
Yeah.
I've said address unknown based on the events that had unfolded that time.
Okay.
And I've explained that in my evidence in chief and during the cross-examination last year, my lord, in the issues of the address and the bail application, my lord.
Manje ke kuleya ncwadi egunyaza ukuboshwa kwabantu uthi ke wena inkosi yenkantolo yabuza ukuthi uye wabhala yiphi address ke yakammangalelo oqala uthi ngiye ngabhala ukuthi address angiyazi njengoba bese sengichazile konyakenye uma ngiphana ngobufakazi bami futhi ngabuzwa nemibuzo nakhona ngachaza nalokho.
Yes.
And I'm not sure, my lord, whether Mr. Mgomezulu is insinuating that a prison is a residential address, because it's clearly asked on the J50 application, on the warrant, address, which is a residential address. You can't now put a building, correctional services as a residential address. I've never seen that.
Manje ke anginaso isiqiniseko sokuthi mhlawumbe umnumzana uNgomezulu uchaza ukuthi ijele yindawo ekuthi mhlawumbe ingasetshenziswa njengekheli ngoba mina angiboni ukuthi ngabhala ikheli ngithi lo muntu usejele usekaboshiwe ngalesikhathi ngifaka lesicelo leso.
Mr. Ginenda, you don't even understand yourself. Listen to this. On the 30th of May 2020, first time we met Sbi in Vosloorus. You allege that he made a confession. That's your evidence. Immediately, spontaneously, you look for somebody who can take a confession. And you knew at that time where was Sibia kept.
But that's not correct, my lord. On the 30th, that was the first time accused number 1 was arrested insofar as the drug dealing matter. So that was the first time he was arrested. It was before he was even incarcerated officially, in other words, being detained in the holding cells.
Uthi ke manje mina ngithi kuwe ubaba uNgomezulu uthi kuye nge-30 zika May uma uhlangana nommangalelwa uSibiya wena uhlangene naye eVosloorus bese uthi uye wafuna ukuyozigunyulula la ukuthi uye wafuna umuntu bese ke kwagcina seyikuthi ummangalelwa useka yokhuluma nje kanjalo uthi cha mina ngithi ummangalelwa nge-30 ngalesikhathi bengiqala ukuhlangana naye ezoboshelwa leliyacala lokuleyidakamizwa akusukuthi ummangalelwa ngaleso sikhathi bese sekaboshiwe.
And my lord, the issue of getting, as Mr. Counsel is suggesting that I've made arrangement for spontaneously for someone to obtain his confession, that's the best practice. You try and get someone independent to document the confession. It is done that way, so that there's no issues of compromise or having interest in the matter. That's how it's done. There was nothing spontaneous about it.
Futhi njengoba ukhuluma nangokuthi ngiye ngathola umuntu ngaso leso sikhathi uthi vele into ekwamele yenziwe ngoba wena usuyazi ngecala kwamele uthole umuntu ongenalo ulwazi ngalelo cala oyikuthi uzokwazi ukuthi athathe i-statement salomuntu ofuna ukuyokhuluma.
I don't want to rush you and you don't want to rush me. I'll get into that aspect of the procedure of how to take a confession. But my concern is when you met Sibiya for the first time, you questioned him to the extent of explaining his constitutional rights relating to this case. I'm not talking about drugs cases here. I'm talking about the murder of Senzo Meyiwa. You allege that he made a statement and immediately you took a decision that this person is confessing. Let me do the formalities. My concern is when Sibiya was already arrested on a J50 by Sergeant Mkhula, he was already under arrest.
I don't understand what is the question, my lord.
Let
Maybe
me
just-
repeat it for you, because you tend to explain things that you don't even understand yourself. The question is, when Sibia was arrested on a J50 warrant of arrest applied for by Sergeant Muhula, when he was brought to you on the 30th of May at Vosloorus, he was already under arrest.
My lord,
That is a good place, my lord. I think the counsel owes the witness courtesy in cross-examining him to say that he explained things that he doesn't understand. I think it's simply rude, overbearing, and we submit that part should be withdrawn.
Yes, Mr. Let's hear you.
It's I would say, I'm glad if my colleague can pick up that. But if that is done by this witness, I'll make an example of what he's saying. Mistakenly, I've uttered words and said, you read the rights of the accused. Out of insinuation, he said, no, I didn't say that. I understand what I was saying, and he better understood what I was saying. He said, no, I said I explained the rights, not I read the rights. So I'll take him according to the attitude he wants to address me on. But as long as he's going to maintain the decorum of this court. The question that I'm still maintaining is, I'm going to establish and prove before this honorable court that when this application was brought on the 23rd of October, when it was brought, it was unlawfully granted or unlawfully obtained on the 23rd, because this accused person was already in prison. What is of pivotal importance is here, what do you submit as facts to the magistrate who's going to grant or issue that warrant? If the address appears to be unknown, obviously in the mind of the presiding officer will say it must be circulated for this person to be arrested. Then what to go to section, I'm trying to explain this so that we are in the same picture, Your Worship, my Lord.
You are not with this witness.
No, in terms of the law. But with this
He
witness,
also
that's
says
why I'm...
that- he also says in terms of the law, you are not in the same picture. Am I correct, sir?
Absolutely, that's what I'm saying.
That's how I understand
Yes,
it.
section...
What, Mr. Gomezulu? Otherwise, we're going to be here until Mandela is resurrected. Why don't you put your version of what you are arguing the law is going to say, and let this witness respond to that?
My Lord, I'll do that.
Because now you're putting a version,
I'll do
or
that.
a snippet of a version, and he says to you, no,
I'll do
I
that.
didn't know where his address is, because I remember you saying you guys went down to go and check Nongoma, and
Correct.
he was not known there.
Correct.
I
It
mean,
was known,
but
but he comes
You
on-
see,
on
you see,
visits,
my Lord, look at this. Look at this. Look at this. That's why at some stage when I address the court, it will be like I appear to be sarcastic. No, my Lord, the evidence of supporting this witness, to say he went to the extent of looking for this witness, the witness that was already incarcerated, it's a redundant application, especially for section 43.
No, it's not.
I'll
It's
submit
because he
it.
says they were going to check his residential address.
Correct, ma'am.
That's what the law says.
For what?
You arrest a person, no, Mr. Gomezulu,
My-
please, otherwise we're going to be here.
My
you
Lord.
arrest, oh, no, wait, let me tell you my experience. You arrest a person, and then he wants to bring a bail application. He's inside the cells in jail.
Yes.
And then the state says we are opposing the application for bail because we want to ascertain the residential address of this accused. Is that not
Yes.
so?
It is so,
And
ma'am.
then you leave them in the cells, you go to Nongoma. That's
It's-
what he says.
that's
And
a
he says
different-
when he got to Nongoma, he went to a particular address furnished by the very witness.
He was actually with us, my lord.
Oh,
I
he-
booked him out and I drove with him.
And then they
to
said, we
Malabo.
don't know this man.
They said they know him, my lord, but he comes on regular
Oh, I see. Fine.
visits.
It's even worse. The applications are not the same.
Okay, what else,
Application for
Mr.
bail
Mugolo?
application is not the same as the warrant. A warrant of arrest, my lord, let us be honest. Section 40, which deals with the warrants with or without a, that's when you deprive a person his freedom. Literally, that means you deprive the person
If he
his
has
freedom.
transgressed the law.
That's correct.
If he has not transgressed the law, you deprive him of his freedom. You're right.
Yes, you can deprive him even if there are allegations that cannot be founded at a later stage.
fine.
Once they withdraw charges or he gets acquitted
Okay.
or whatever.
So
But
what else do you want to put to this witness?
you know, the reason why I had to deal much on section 43, I want to make fruitful, I'll put it that way, fruitful submission during my argument.
Okay, fine. Are you through now with?
Accused
Section
number
43.
1 and number 2 were already arrested. And my lord, I don't want to remind the court about the attitude of the court towards the defense and the attitude of the court towards the witness, because
it?
that will also constitute unfair trial.
What's the attitude now?
No, even that, I don't want to go back to the records, my lord. I'm just checking when the witnesses are testifying, what is the attitude of the court? May I request the court to remain impartial? May I
I'm
request, if the
impartial.
court, sorry, my lord.
I'm impartial. The only thing I'm doing in this court, I'm quoting the law as I understand it.
I've indicated
That's
earlier
all.
on, when I was cross-examining Mkhola, I said, after the examination of Gininda, I'm going to bring an application under section 371 to make it-
317.
317, a
Yes, I
special
know the law.
entry.
317.
Yes, a special entry.
Yes.
Because of what I've picked up during.
Okay, no problem. You're
Yes.
at liberty to do that.
Hence, I'm saying my problem is with the application. Let me just put it this way. When you were, after Sibiya and Danzi, after Sibiya and Danzi were charged for the Senzo Meyiwa case, there were so many rights that were explained in relation to 636 during their arrest. You remember?
My lord, I remember, but I would like to start on the aspect that the state advocate objected on. I think, with utmost respect, I don't believe I've treated Mr. Mgomezulu with disrespect. The fact that I differ with him with regard to the version that he's putting based on the evidence that I have in court, I mean in the docket, is not a sign of disrespect. But I've never spoken to him with any disrespect, and I would like him to treat me the same. I'm here to assist the court. I will answer him insofar as the question that he wants to know, and there's no reason to get emotional on this. Let's just do the business of the day, be professional about it, and move on. That's all that I want to ask him.
Brigadier uthi-ke ithi niqale la ubaba uBaloyi uye wasukuma ethi kunento afuna ukuyiveza, uthi ngithanda ukuveza lana nami ukuthi angisukuthi umnumzana uMngomezulu angimhloniphi, ngiyamhlonipha nanoma ngiphendula ngimphendula ngenhlonipho, njengoba naye sekachaze ukuthi ubona ingathi angikhulumi naye ngokumhlonipha, uthi cha lokho akukho njalo. Mina ngicela ukuthi sibe la sixoxe lolu daba olusilethe la, siyenze ukuthi lelicala liqhubeke, sikwazi ukuthi sisize inkantolo, sisebenzisane ngokuhloniphana. Uthi ngiyamhlonipha naye akangihloniphe, sihloniphane sihloniphe inkantolo.
I will refrain from such a conduct as long as we are in the same path. And this is not a condition. I'm just saying it, and I withdraw if I offended you. But let us take each and every question and answer in a way that will assist this court to see if such confessions were taken properly.
Yes, I agree, my lord, but in answering that, I cannot agree to things that I see are intending to create a wrong impression to the court. That's what I'm here for. And if I point those things out, Mr. Mgomezulu must understand that I'm simply here to assist the court. There's nothing personal about it. I'm raising what I'm raising based on the investigation that I've conducted. It's nothing personal. And if you want to challenge me with that and point me to another direction, if of course the facts are there, I'll concede. But if the facts are not there, I can't concede to something that is wrong. But that is not meant as a sign of disrespect. It's what we are here. We are here for that, my lord.
Mnumzana Mgomezulu ke uthi ngizoyeka ke lokho njengoba uthi sihloniphane, ngizoyeka ukuthi singahloniphane, sizohloniphana, kodwa uma ingabe mina nawe sizovumelana kwizinto ekuthi ngiyazibuza, ubrigadier uma iphendula uthi yebo asihloniphane, nami ngizoyenza ukuthi ngiphendule imibuzo ngalendlela uyibuza ngakhona, kodwa uma ingabe ikhona indawo ekuthi ufuna ukungisa kuyona eyikuthi mina angivumelani nayo, ngeke ngivume, ngizoyenza umsebenzi ukuthi mina bengikade ngiphenya kuleli cala futhi ngisize inkantolo ukuthi inkantolo ibe nesinqumo ekuthi yasithatha. Angizanga la ukuthi ngizothatha izinto ngenhliziyo, asebenzisane ungibuze ngiphendule bese sikwazi ukuthi leli cala siqhubekele phambili.
Now, my lord, I'll come to the last question, but the first, perhaps maybe let me try and deal with what I remember what Mr. Mgomezulu raised, my lord. The issue of the J50s, and this is my understanding, that's why I said him and I have a different opinion. We've now read section 43, I think it's clear daylight. But secondly, the warrant of arrest or the J50 is a means of taking someone to court. It must not be construed as the violation of the rights of the person that has been arrested. In any event, the Constitution, my lord, section 36 has a limitation clause. Once this case is made and the warrant is authorized, what do? The person must appear in court. And the warrant of arrest is the means of taking the person to court, as it can be summons, any other thing. I'm not aware of any provision in section 43 that says if a person is in custody, you cannot execute a warrant. I'm not aware of that. It was a means that was before us. The case that they were facing, my lord, is premeditated murder. I mean, even if the person was outside, how do you go and warn a person outside to say, you've killed the person X on this day, you must go and appear on your own? There's no way. It will amount to J50, my lord.
Uthi-ke ithi nichazele indaba le yamaphepha agunyazayo ukuboshwa kwabantu, mina angiboni ukuthi lamaphepha lawa ayewakhishwa ngendlela engekho emthethweni, ngoba mina umuntu nanoma engaphakathi kodwa njengoba ebhekene necala elibucayi ukufana nalo leli cala lokuthi uye wahlala phansi wacabanga ngokuyobulala umuntu othize, mina ngokwami ngiyazibuza ukuthi ke uya kanjani kumuntu nanoma engaphandle ufike uthi kuye ubhekane necala lokuthi wena uye wacabanga ukuthi uyobulala umuntu bese ngelanga elithize uye enkantolo, ngoba isizathu sale ncwadi le egunyazayo ukuthi umuntu aboshwe ukuthi lo muntu loyo ube nalelo phepha bese uyaya uyombopha, akusukuthi uye uyomcebisa ukuthi ngelanga elithize kwamele uye enkantolo. Uthi manje lokho yiko engifuna ukuchaza ngalo lemicala.
Lastly, my lord, on the last part that Mr. Mgomezulu asked me, my lord, yes, there were rights that were explained prior to the execution of the J50s on accused 1 and 2. Insofar as the questioning that took place prior to the arrest, they were questioned at a certain stage on the 30th, and whenever we engage with them, constitutional rights as prescribed and required to do so were explained to them. But insofar as the arrest, my lord, that took place, in other words, the indictment of them and the charging formally of this matter on the 26th, that was explained in terms of 14A, as also prescribed, my lord.
Manje ke ithi ngiphendule lo mbuzo lo bengibuzwe ngawo uthi yebo amalungelo wona akhona ayikuthi ayewachazelwa umangalelwa maningi, kodwa ngaleli cala kuye kwafanele ukuthi simchazisele futhi amalungelo, ngoba lawayana bekwamalungelo welinye icala ngalesikhathi ezokhuluma futhi kube kwamele ukuthi simbuze simchazisele amalungelo wakhe ngaleli cala, njengoba na kuleli cala bekwamele siyenze ukuthi sithole le phepha egunyaza ukuthi aboshwe bese siyambopha ke, ingakho bekwamele simchazisele amalungelo wakhe.
Okay. You gave your own understanding of section 43. My question now is, in your affidavit, did you ever mention that accused number 1 or number 2 was arrested for another offense. Did you mention that in your affidavit?
I beg your pardon, just what is the question, my lord?
My question is, when you brought your application, it was supported by an affidavit.
Yes.
In that affidavit, did you state clearly that accused number 1 and number 2 are in custody or were arrested?
I'm not sure, my lord. I'll have to refresh my memory. I mean, I've made that application in 2020. The important thing, the background of the case that was stated, I know that the evidence insofar as accused 1 and 2 that I was making the application on, I'm sure I've stated that. But as to where they are or where they were at the time, one will have to refresh my lord. But the defense has also the copy, and I've got, I can go through it if that's what they want, my lord.
Uye wabhala na kwi-affidavit yakho ukuthi abamangalelwa ngaleso sikhathi bebakade bebuphi noma bebakade beboshiwe, uthi anginaso isiqiniseko kodwa ngiyacabanga ukuthi ngichazile kule affidavit yami ngoba ukuthi ngiye ngasho na ukuthi baboshiwe noma cha, lokho kuzofuneka ukuthi ngiye mhlawumbe ngifunde statement sami futhi kodwa unaso ummeli nami nginaso, uma engabe kuyavumelela ngahle ngibeke bese ngiyakwazi ukuthi ngiphendule yebo noma cha.
And last, my lord, the application was not about the verification of address. So I just want to say this. It was about the J50. It was not a statement to say whether the address is positive or negative or they're staying there, So they might be there in terms of the background of where they are. But even if it's not there, my lord, that was not the essence of the application. It was the evidence that I had and the request for the J50 authorization.
Futhi ke leso sicelo bekungasi isicelo sokuthi siyavumelana noma asivume ukuthi ikheli labamangalelwa ilona noma akusilona, bekuyisicelo esigunyazayo ukuthi sithole igunya lokuthi siyobopha abamangalelwa. Yiyo inyinto emsemqoka ebengifuna ukuyichaza.
Let me just put it to you by saying, if that is the statement you made under oath in A198 statement, if that is the application, that's the statement or affidavit in support of an application, I'll ask you to go through that statement. But in the meantime, I just want to put something to you, then you can comment on that one. If you brought an application, that's what I'm putting to you as a matter of law. If you bring this application and state clearly in your affidavit that accused number 1 was in Moda B and accused number 2 was at Pukeng police station, I'm making an example. The court, the magistrate court, was not going to grant that application. Do you agree?
No, I don't agree because you are now, I don't know, I don't agree, my lord.
Uyavuma na ukuthi ngalesikhathi wenza le sicelo lesi sale ncwadi egunyazayo ukuthi abamangalelwa baboshwe kube uye wachaza ukuthi ummangalelo oqala mhlawumbe umzekelo use Moda B, ummangalelo wesibini yena mhlawumbe use Pukeng police station, ngaleso sikhathi leso sicelo besingeke sivunywe uthi cha, lokho ngiyaphika.
Perhaps counsel, my lord can refer me to a section that says if a person is incarcerated, a J50 warrant cannot be issued. Then perhaps we can close this matter because I'm not aware of such.
Mhlawumbe ke uma ummeli angangibonisa umthetho othi uma engabe umuntu eselaboshiwe akwamelanga ukukhishwe incwadi egunyazayo ukuthi lo muntu angaboshwa kwelinye icala, mhlawumbe singakwazi ukuthi sivumelane noma siqhubekele phambili.
Yes, it's fine. You can say that or you can ask for that law, but I'm still putting to you that the proper way of securing the attendance of these accused persons who were at that time of the application were in custody was to requisition those accused to the relevant court for their first appearance. Do you agree?
As a please, my lord, that question is unfair, it's wrong. The witness has...
But they haven't appeared in court anyway.
Yes.
How do you requisition?
Yes.
As I understand the law.
Yes, in any case, the witness has already said that a warrant is a way of securing the attendance of a person in court. And Section 38 clearly states, my lord, that The method of securing the attendance of an accused for his or her trial shall be arrest, summons, written notice, and indictment in accordance with the relevant provisions of this Act.
That's the only way.
The question that my learned friend is putting to the witness is
That's Section 38, sir.
Yes, Section
It
38.
doesn't talk about requisition. Hello? Does it
Yes.
talk about,
No, it doesn't talk about
does it talk about requisition?
No.
Okay.
It talks about a summons.
Yes, someone's fine. Section 72(5)(c), I think. Hello?
I was listening to
No, I'm
the court.
quoting the law.
I didn't hear what the court was saying.
No, you know the law. I was saying to the gentleman who's saying he talks about a summons. There's a way it deals with what a summons is.
Yes.
Yeah, fine.
Mark, I'll still maintain, I'll get into the part where, even if you say there's no such a law, my concern is when the application was brought, there was an information that was not disclosed fully to the presiding officer.
Not the address, how is it relevant to the evidence? What the presiding officer and the prosecutor, who obviously both of them signed the warrant, needed to know the strength of the case, whether such warrant can be authorized. And the decision was taken based on that, and as well as the indictment that I referred to. So the issue of address, like I've said, my lord, if counsel perhaps can say to me, this is a section that says you cannot get warrant of arrest or warrant signed by the magistrate when a person is in prison are unlawful, then we'll find each other. Because like I'm saying, I'm not aware of such, my lord, and there's no law that says that. And secondly, lastly, my lord, as I've said earlier, warrants of arrest are one of the means to bring people to court.
Uthi-ke manje mina ngiyakutshela ukuthi ngalesikhathi wenza lesi sicelo kunezinye izinto ongazivezanga kuleya ncwadi egunyaza ukubopha umuntu. Uthi anginaso isiqiniseko sokuthi ukhuluma ngani ngoba ngiyacabanga mina ukuthi le ncwadi egunyazayo ukuthi umuntu aboshwe incwadi ezoyenza ukuthi lo muntu sikwazi ukuthi ayovela nasenkantolo. Uma ingabe mhlawumbe ungangibonisa umthetho oshoyo, mhlawumbe singakwazi ukuthi sikhulume into efanayo, kodwa okwamanje mina ngisamile ekutheni incwadi leyana ngiyifake ngendlela esemthethweni, ingakho iye yavunyelwa nayo inkosi yenkantolo.
The J50 warrant of arrest, I'll just pass the issue of address, but it is relevant, and I'm going to make submissions on that irregularity in terms of granting or issuing that warrant of arrest. Now let's get into your statement. I think it's A198, if I'm not mistaken. Your affidavit, are you in possession of that, sir?
For the application, for the J50 warrants?
Yes.
No, I'm not, my lord. I'm not, my lord. But my lord, to say the application, the issue was irregular, I disagree. There's no
That's
such.
for the court to
I
decide, my lord.
No, it's not for this court to decide, it's for
Yes.
you, Mr.
Yes, I'll make
Mr.
submissions. At the end of the
Zulu, to
day.
bring an application reviewing the decision of that magistrate to say that when he granted that warrant on application by Brigadier Belinda, the law was not permissible for him to do that. Not the witness himself. Unless you accuse him of fraud, fine. Fine.
Are you in possession of that?
Yes, I am.
Am I correct to say it's A198?
Yes, 198, that's correct, my lord.
Do you need some time maybe to check if the aspect of the address has been canvassed on the affidavit?
I can, my lord, but like I said, I can. If
Yes.
defense wants me to do that, but I've already dealt with the matter.
Now, I
The
just want to
issue-
place it on record, Mr. Kinenda.
I will, yes, my lord.
Yes.
But what I'm saying, what must be clear, there is nowhere where the issue of address is a prerequisite for getting a J50. You don't get J50 unless you are saying the person, because even if the address is wrong, if the elements of a crime are not there and the person didn't commit that offense, why would the judiciary sign the warrant of arrest? The basis of this application and authorization was based on the evidence collected insofar as accused 1 and 2 are concerned, my lord. But I will check if
No, this court wants to know what's inside that warrant.
Usiphethe na
That
istatement sakho.
application, the court must also know.
Usiphethe istatement sakho uthi yebo ngisiphethe uthi ungasibonisa na la ukhulume khona ngekheli likammangalelwa uthi lokho ngingakwenza kodwa angiboni ukuthi kumqoka kanjani ngoba awukho umthetho ongivimbayo ukuthi uma ngingenalo ikheli likammangalelwa ngingahle ngifake lesicelo. Manje mina ngibona ukuthi lesicelo ngasifaka ngendlela esemthethweni uthi ngakwenza lokho na njengoba seka sibheka istatement sakhe efuna leyo ndawo la ikuthi kubhalwe khona.
But you're going to read that statement, sir? Were you suggesting the same, Mr. Baloyi?
No, I want to point out that my learned friend wants to use a statement that he hasn't proven as yet. He must first prove the statement, then follow
No,
the
it's okay. He doesn't have to prove it if he wants this witness to read it under cross-examination. Okay. That's the law.
Well, we still maintain that if you want to cross-examine on a statement, you first have to prove it.
No, fine, but not under these circumstances because they're not at either. Just read that for everybody to know what is in that document.
All right, my lord. So it says, I, the undersigned, Bongani Nicholas Kininda, state under oath, as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the Commander for Cold Case Investigation Unit of the National Commissioner, with the rank of a colonel and the service number. I've mentioned the service number as well as the telephone number. That's paragraph 1.
Na yike iparagraph yokuqala
Let him finish first.
as the court places statement, my lord.
I am the lead investigating officer of Phosphorus 636-10-2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that 2 black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witnesses stated that one of the accused was carrying a firearm, purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as a tall, slender, neatly shaven and dark in complexion. It is stated under oath that during the robbery in the same house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Meyiwa on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one of the cellular phones belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others, a hoodie, were standing hidden away about a few meters from the crime scene prior to the incident, appearing to be typing on their cell phone. It is stated that the suspect fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identities were compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 8:30 and 2100 hours, my lord. The deceased was declared dead on arrival at the hospital at 21:15. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost during covering the area of Phosphorus hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under will indicate that the planning of the offense and gathering after the incident took place at Phosphorus hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa. The suspect in question are as follows. 3.1 Musika Ukulelwa Sthemba Sibia. He was first linked to this offense by means of witness statement under oath. The accused boasted to individuals closely associated with him in KZN homeland as to his involvement, together with Mafika, herein as under suspect 2, Carlos under suspect 3, Mapisa suspect 4, and eNCA suspect 5 into killing of the deceased. A dispute ensued between the individuals and the closely associated individual disclosed to the ACPS the admissions these accused made to them. The accused was further linked with circumstantial evidence wherein minutes after the incident made disclosure and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo even before the death was reported in the media. He is further linked by means of a formal confession he made to the Commission Independent Officer on the 30th of May 2020. The suspect further made a formal pointing out the sequence collection prior to the incident, the guarding of the outside of the house during the assassination, and the dropping of the accused at the cell phone tower referred to herein above. Second one, 3.2, Bongani Sandison Tanzi, nickname Mafika. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identity compiled through description of witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and he was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and compiled identikit. During the questioning, the suspect during the questioning and the subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. Hereafter, the suspect indicated his eagerness to confess as to the involvement in this matter. The suspect made a confession to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as a tall, slender build which came into the house. 3.2, Tobisi, friend's nickname Carlos Mobe. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, Further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was sentenced prisoner serving 35 years imprisonment for the murder committed in 2015. Ballistic test revealed that the same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloadings of this cell phone were done. The photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver upon entering the house. Photos downloaded taken of the accused by himself or selfies match the description of the suspect who had a firearm with red locks, big eyes, and with the gold teeth. This is the suspect. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Photos were actually found of the murder weapon used in the murder of Senzo Meyiwa. 3.4, Mthokozisi Ziphozonke Mapisa, also known as Mapisa. The suspect is linked to this offense by means of certified sworn statement and referred to herein above. He is further linked by means of confession he made to a private person, a close friend, about his involvement in this matter. This confession came about in that the suspect requested this private person to establish reasons why suspect Mafiga was arrested. The information disclosed was that the suspect Mafiga was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person returned disclosing this information to the suspect Mapisa, did Mapisa instruct the private person to return to and inform Mafiga, that is accused to not disclose his Mapisa's involvement as he, Mafiga, will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5, Sifobuhle Nkani Ntulu, also known as Nkani. The suspect is linked by means of sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo. Evidence also revealed that he drove the car with the suspect to the same scene and back to Phosphorus Hostel after the incident. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafiga, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the said vehicle prior and after the committal of the murder in the company of the referred suspect. The above suspects are also known to be hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35, Act 108 of 1996 by me, and questioned for this incidents. Some of the suspects made confessions to the independent commission officers as well as the magistrate as indicated above. Others made confessions as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence by means of sworn, collaborating, and independent witness statements establishes a causal link between the offenders and the offense of murder, robbery with aggravating circumstances, possession of unlicensed firearm, and the unlawful possession of ammunition. The Director of Public Prosecution Gauteng Division, on a directive of the National Director of Public Prosecution, issued, after careful consideration of the presented evidence, that the above 5 suspects in paragraph 3 must be arraigned for murder, robbery, and aggravating circumstances, as well as possession of unlicensed firearm and ammunition. The instruction are attached with the statement as B and G1. I hereby apply for the warrant of arrest for the following suspect on the above indicated charges on this paragraph. Then it is the names of accused 1 to 5, my lord. Then it's the oath, and the statement was commissioned on October the 3rd, 2020, the 3rd of October, my lord.
Naso-ke istatement sika-Brigadier Udinayina ngamafuphi istatement lezi sichaza ukuthi uyenzeni yena ngaphambi kokuthi aze azobhala lesi statement la ukuthi uyachaza nokuthi abamangalelwa bona bafakwa kuleli cala bayenzeni, futhi kunala ukuthi uchaza ukuthi umangalelo oqala uye wahamba wayekhuluma nobani umuntu bekade sondelene naye, ingakho ukuthi lo muntu loyo uye wagcina sekuthi uyotshela amaphoyisa, bese ke umangalelo oqala kula ebandakanyeka khona. Lo mangalelo esibini naye kunezinto ukuthi uye wazikhuluma ebekade ezikhuluma kumuntu othize naye ubandakanyeka ngaleyo ndawo, naye ukuthi umangalelo wesithathu uchazwa umangalelo wesibini ngalesikhathi ebekade ekhuluma egunyuluka laphayana ukuthi yena uthi bekayenzani kula, nawo umangalelo wesine naye uyachazwa khona lapho, futhi ingathi ikulesa statement sikamangalelo wesibini. Umangalelo wesihlanu yena uchazwa njengomuntu obekade naye ekhona, futhi uyena umuntu obekade eshayela imoto le bekade kuhanjwa ngayo ngalesikhathi kwenzakala leli cala leli. Leli cala leli kwenza liqale ingathi bekade kuyobanjwa nje inkunzi, kodwa kugcine sekuthi kuyabonakala ukuthi bekungasi nje ukuyobamba inkunzi okujwayelekile, bekade kuthunyelwe noma bekade kunolwazi lokuthi kuyoyenzakalani khona lapho, futhi labantu laba bekade beyingxenye yokuthi leli cala leli liyoyenzakala. Futhi kuchaziwe nalana ukuthi umangalelwa ubekade owesithathu ubekade yena ngaphakathi kwicala ukuthi lenzakele ngo-2015 lokuthi nalo bekade sekuthi unikwe isigwebo seminyaka engama-35 la ukuthi ubekade ebhadla ejele. Kodwa ke ubrigadier uthi naye uye wayenza uphenyo lwakhe, ingakho egcine sekuthi ubhala lesi statement. Ngamafuphi nje akusiyonke into ayibhalile, kodwa bengizama nje ukuthi ngithi ukusibamba laphayana nalaphayana lesi statement.
My lord, I just want to correct also the date in which the statement was signed and commissioned. It's actually the 23rd of October 2020. Sorry, not the 3rd, so it's 23 October 2020.
Ke futhi enye into idate yale statement la signwe khona akusiyi 3 yi 23 zika October 2020.
Yes, Mr. President.
Thank you.
Mr. Please, Molo, just before my learned friend cross-examines, we just want to caution my learned friend against this course of cross-examination that is embarking upon. We must keep in mind that we're busy with a trial within a trial. And the purpose of a trial within a trial is to insulate the proceedings from the merits and to protect the interests of the accused should he wish to testify in the trial within a trial, not to expose his flanks to cross-examine on the merits. Now, my learned friend is canvassing issues which pertain to the merits. And should his client now decide to come and testify in the trial within a trial, which must keep in mind that the trial within a trial is concerned with the admissibility of the statements that were made by the accused. Now, my learned friend is now canvassing the merits, which will expose his client to cross-examination on the merits, should he or should both of them decide to testify in the trial within a trial.
Mr. Gomez is an experienced advocate. He knows what he's doing.
That's correct. In response from the submission made by my colleague, I am so grateful that he mentioned the aspect of protection of the client's rights. But what is very important in relation to the contents of his affidavit will be injected also when the argument arises on the admissibility of confession, extracural statement made by.
They're not admissible against another accused.
That's correct.
Yeah, we know that.
Yes.
And by the way, just so that there's no misconception, what Ginanda is reading there is hearsay.
That's correct.
Please.
That's correct.
So, hey, Judge Lay, things are going to give evidence, what? It's hearsay. It's not admissible.
Yes.
But I said he must read it because you were insisting that there are certain contents there which render that application unlawful, as you said.
Correct, my lord.
Okay.
As I've indicated, my lord, also that the gist of these proceedings relates to the admissibility
Yes,
of
yes.
the confessions.
That's it.
Where does I'd say, what factors will the court consider at a later stage if some of the information that is important to the argument that an extracural statement was made which resulted to the arrest of other accused persons. May I proceed?
Yes.
Just to confirm, my colleagues are requesting a short
What's the
argument.
time now?
It's 12 o'clock.
It's 12 o'clock.
It's 5 to 12, my lord.
Until when?
5 past. Until
Okay,
5
quarter
past
past 12, we'll come back.
Mina njengommeli ngiyakwazisa ukuthi thina asivumi lolu daba ukuthi abamangalelwa baye bagunyuluka laphayana umangalelo oqala nowesibili. Uthi ke ubrigadier uma ephendula uthi cha lokho ngiyaphika ngoba abamangalelwa baye bakhuluma nami qala ngaphambi kokuthi baye kulomuntu nomunye. Nakhona uma sebafika lapho ungani bangazange bachaze ukuthi thina asifuni kuyenza lento, asifuni ukukhuluma. Uthi mina baye bakhuluma nami ingakho ngingagcina sekuthi ngibathumela uzakwethu ukuthi bayogunyuluka khona.
The second part, my lord, the accused two in particular, then the second confession was made in the presence of his attorney to the magistrate on the 24th of June 2020. But furthermore, my lord, there was a 105 engagement in terms of Criminal Procedure Act, Section 105 capital A, between the state and the accused while he was legally represented. And in the documentation that we have, they firmly say they stand by the two confessions that were made by accused two.
Manje ke futhi enye into esemqoka ukuthi ummangalelo wesibili wagunyuluka nge-24 zika June 2020 ebekade enommeli wakhe. Futhi kuye kwabhalwa futhi naphansi ukuthi bona bame ngawo lawo mazwi lawo akhulunywa ummangalelo wesibili.
And elected as part of his plea bargaining proposal, my lord, I'm sorry, I must say this because the assertion is that they never made any statement. Insofar as admitting the statement he made, went further in proposing the plea bargaining that he will plead guilty and testify against his co-accused. That is the extent of the discussions between accused two and the state.
Futhi ke akaphelelanga lapho ngokugonyuluka nje ummangalelo wesibili uye wakhulumisana nathi ukuthi ke ake siyenzeni kanje ngizovuma icala mina bese ningenza ufakazi kulo lelicala ngizofakaza ngalolu daba olwenzakele ngikhulume nokuthi abafowethu bayenzeni noma ngisho ukuthi abafowethu kwenzakele.
So those are the reasons, my lord, why I will not believe now that all of a sudden those statements were not made. There wouldn't be that discussion insofar as accused number two, and even if accused number one, in all the appearances, not once was it raised, even in Boxbeck, on the first appearance, my lord, none of the accused, this is 1 and 2, raised the inadmissibility of the confessions that they've made.
Futhi ke abamangalelwa bobabili umangalelo oqala nowesibili akukho nalanga lesikhathi bevela enkantolo naseboxbeck la ukuthi bona baye bachaza ukuthi animancala thina siphuqelelwa ukuthi sikhulume, thina asivumi leyo nto, thina besingafuni ukuthi sivume, thina besingafuni ukuthi sikhulume lento leyo thina siphoqiwe. Bathi cha akukho la ukuthi baye baveza lokho.
When accused number one was arrested on the 30th of May 2020, on the same day he made a confession.
That is correct, my lord.
Umangalelo oqala uma eboshwa nge-30 zika May 2020 kula ukuthi yena uye wagunyuluka khona uthi yena.
And you said you did not know Kenneth Mboto. Am I correct?
No, I said I've never worked with him and he was not privy to the investigation. I don't think if I said I did not know Kenneth Mboto. The person that I said, my lord, I do not know. I've never spoken to him and I've never worked with him and even saw him and saw him for the first time was Lieutenant Kenneth Rapado. I don't think I said the same thing about Kenneth Mboto.
Uthi uye wathi ke uKenneth Mboto bokade ungamazi uthi cha uma ngikhumbula kahle uMbotho ngithe angikaze ngisebenze naye futhi wayekade engenalo ulwazi laleli cala.
Okay.
Mina angizange ngithi angimazi umuntu ongicabanga ukuthi ngithe angimazi uKenneth Rapado.
No, it's fine. Accused number one, when he was arrested at Tembisa, he was then taken to Force Loras. But before he was taken to Force Loras, he said he was beaten, he was tortured to make a confession. Will you dispute that?
Well, my lord, it was not told to me. I was not there when he was arrested. What I know is the engagement that I had with him at Kosoras police station And when we were there is no statement that he made to me that he was tortured or beaten. I've asked him. I actually even took an opportunity of sending away the officers who were there with me and spoke to him away from them, because I wanted to establish exactly that whether he was threatened or he was talking to me under undue duress, and I didn't pick that up, my lord, and I didn't see any visible injuries, nor did he tell me that, my lord.
Uthi ummangalelwa wokuqala yena ngalesikhathi eboshwa ethembisa uye washawa waphoqwa ukuthi ayokhuluma. Uthi ke ubrigadier mina ngalesikhathi elethwa kimi eFosloras akazange akusho lokho. Futhi nalamaphoyisa labe bambopha mina ngiye ngathi bahambe ukwenzela ukuthi ngikhulumisane naye ummangalelwa ngizokwazi ukuzwa ukuthi ngempela mhlawumbe ummangalelwa ushayiwe noma kunento ayenziwe engamphathanga kahle azokwazi ukukhululeka enami sobabini, kodwa akukho na ummangalelwa agcine sekuthi uyasho ukuthi kwenzakeleni kuye.
What I want to establish is when you were talking to accused number 1 at Fosloras, and when you asked those people to give you space, you're the one who was telling Colonel Mboto that a person wants to make a confession.
No, so that's not how it happened, my lord. I warned him, we spoke. When it was clear that he was prepared to make a confession to an independent officer, freely and voluntarily, I then instructed those members to change the direction in terms of where they were going and go to Eraton. While I was driving to Eraton, alone in the car, I phoned numerous officers until I got assistance from Colonel Mboto. So the communication between myself and Command Board and Colonel Mboto was not in the presence of accused number 1.
Manje ke ummangalelwa ngalesikhathi uze kuthola uKennel Mboto wena ubukade unaye uthi cha mina ethema kulibele besahamba naye ummangalelwa kulayi ukuthi ngiye ngabacebisa ukuthi baye ngase Eraton, mina ngangishayela ngedwa la ukuthi ngiye ngashayela ucingo amaphoyisa amanye ahlukile kulayi ukuthi ngicine sengithola uncedo kuye uKennel Mboto ngalesikhathi ummangalelwa wayekade engekho nami enalamanye amaphoyisa.
All right. My question is, when you communicated with Colonel Mboto, that was you who informed him that there's a suspect who wants to make a confession.
That is correct, it was me, my lord.
Uthi yebo ngalesikhathi ngikhuluma noMbotho ngiye ngamtshela ukuthi kunomsolwa ofuna ukuyokonile.
Okay. I just want to establish if you heard accused number 1 telling Colonel Mboto that he wants to make a confession.
No, my lord. As I said, my discussion with him was, are you prepared to make a confession to an independent officer, not Colonel Mboto? I did not know which officer I would find at the time. So, and as I said, when the communication of only various officers were made by me, the accused number 1 was not there. So I didn't ask him to make a confession specific to Colonel Mboto because I did not know who will assist me at the time.
Manje ke umzwile na ummangalelwa yena ekhuluma kuKennel Mboto uthi cha ngalesikhathi mina ngikhuluma nommangalelwa bengingakatholi ukuthi ubani umuntu ozongisiza ukuthi ummangalelwa akhulume, futhi ummangalelwa angizange ngithi kuye uzimisele na ukuthi ungayokhuluma noKennel Mboto, mina ngithe uzimisele ukuthi ungayokhuluma nomuntu ongekho la phakathi kwethu oyekuthi kuumuntu okhululekile ole eceleni.
But you will not disagree with the accused if he says he did not tell Colonel Mboto after he has been appointed or whatever way. But he says he did not communicate to Mboto that he wants to make a confession. You cannot dispute that. That was only said by you.
I don't follow, my lord. Which part was said by me?
May I rephrase it?
Yes.
I would say accused number 1 did not make or did not say he wants to make a confession to Colonel Moto. That you cannot dispute.
No, my lord. As I said, there was no mention of Colonel Mboto in my discussion with him. It was a discussion of, are you willing to freely and voluntarily make this confession to an independent officer, someone not attached to this investigation? The answer was yes.
All right.
There was no specific name given that this is the person who will take the confession.
Ngicacise kanjena Nkosi yenkantolo, mina angizange ngithi kummangalelo wokuqala uzimisele ukuyokhuluma no Colonel Mboto. Mina ngithe uzimisele na ukuyokhuluma nomuntu ozimele ongekho lapha phakathi kwethu. Angizange ngimnike igama ukuthi eyokhuluma nobani.
Okay. May I rephrase it by saying, accused number 1 did not say they want to make a confession to that independent person. Will you dispute that? That
Yes,
he
sir.
never said that.
No, absolutely, I'll dispute it because he said it to me. He said it to me, hence I made those arrangements. If he did not say it, I was not going to make those arrangements.
Manje uzophikisana nommangalelwa na uma yena engathi akazange athi yena ufuna ukuyokhuluma nalo muntu lo obekade ezimele. Uthi yebo lokho ngizokuphika ngoba bengeke ngiyenze ukuthi ngithole lo muntu uma ingabe ummangalelwa wayekade engashongo ukuthi ufuna ukuyokhuluma nomuntu ozimele.
That's the reason why accused number 1 says he was subjected to torture, he was choked for him and for you to make such arrangements. He did not voluntarily make such a statement. There was a prior act or action that was taken against his will. Later, you then made arrangements for the taking of the confession. That's what you say.
My lord, let me understand so that I don't answer haphazardly. Is the defense saying accused 1 was tortured in my presence? Because I understood him to be saying he was tortured in Tembisa, then brought to me. So is that what the defense is saying, or is it now saying, or the version is that he was not tortured in my presence? So that I'm clear in my response.
Let it be clear. Accused number 1, he was tortured in Tembisa when he was arrested. Taken to Phosphorus.
I've answered
I did
it.
not mention
Sorry.
torture in your presence.
Oh.
I just said when you allege that he made a confession, he was subjected, I didn't specify the place where. He was assaulted by the police. As a result, when you arrived, that's then the issue of taking a confession happened. Because according to him, he did not speak to any independent person to say, I want to make a confession.
My lord, he spoke to me prior to Colonel Mboto. Prior to me meeting him, I got a call from Sergeant Mokola who told me that he was making some sort of admissions. Hence, I then said, bring this person to Phosphorus ACPS so that I can talk to him. When we met, my lord, there was no indication of complaint that was said to me by accused number 1 insofar as being threatened or tortured or anything whatsoever. I asked him this question when I was trying to establish that he is making this, willing to make this confession freely and voluntarily, and that he understood his right. He didn't say such to me, my lord, and I did not see any visible injuries or signs of being in pain, things like that. I did not read anything to that effect, my lord. Otherwise, I would not have proceeded making such arrangements.
Mina kimi ngalesikhathi ummangalelwa nginaye angizange ngibone impawu zokuthi mhlawumbe ushayiwe noma ulinyaziwe noma uphoqelewe ukuthi agcine seyikuthi ufuna ukuyogonyuluka, ngoba uma bengikade ngibonile bengizombuza bese ngiyenza isiqiniseko sokuthi lo muntu lo akayenza into eyena angayifuni. Mina ngimbuze imibuzo ngizama ukwenza isiqiniseko sokuthi ngemva kokuthi umhula sekamlethe kimi iqiniso nawo ukuthi lento umhula angitshelayo ukuthi ingathi ummangalelwa yena kunezinto azikhulumayo ezenza ukuthi manje kuzofuneka ukuthi kutholakale umuntu la azokunyuluka khona. Ngifike ngambuza nami ukuthi iqiniso na kube bengibone lezo impawu bengeke ngiqhubeke.
Okay. Now, at that time, when the alleged confession was taken, after the confession was taken, the alleged confession was taken, what was the step that you took to charge the accused? Because now we have some kind of evidence implicating accused number one.
No,
What
there was,
step did you take?
so, my lord, there was no step. It was not necessary. There is no, with greatest respect, my lord, I don't mean it to sound it in a bad way. There's no law that says once a confession is made, a person must be charged. Unless a person says, I'm pleading guilty, take me to court. And that is why, with insofar as accused number 2, we had this 105 capital A arrangement. Those are the processes that are undertaken. So you don't, because when a person confesses, he's simply saying, I'm admitting my wrongdoing, then there are processes that will be put into place to finalize the matter. You don't just turn and charge a person just like that. And if it's investigation, my lord, I needed personally to corroborate what was said, to get more evidence, establish whether what he is saying there's authenticity in it. So there were a lot of things that needed to be done before you can come to the finalization of that confession matter.
Eziphi inyathelo ezithathile ngemva kokuthi ummangalelwa sekagunyulekile ukuze uzogcina somphese icala uthi cha akusukuthi kwamele kube nezinyathelo ezithathwayo umuntu mayeqeda ukugunyuluka, kwamele lo muntu loyo mhlawumbe yena uma engathi uvuma icala bese ke ngiacele yena ukuthi ngiyisene enkantolo kula ukuthi lo muntu uthathwa ayisiwe enkantolo. Kodwa ngemva kokuthi umuntu sekagunyulukile akusukuthi kwamele athweswe amacala, kwamele kwenziwe isiqiniseko cala sokuthi lo muntu lona lento azikhulumayo zineqiniso elingakanani, ziyiqiniso elingakanani, futhi lezo zinto uzikhulume kahle ngale ndlela bekade vele bekwamele azikhulume ngayo, ngale ndlela yena azi ukuthi kwenzakele ngakhona. Ingakho kuye kwagcinwa seyikuthi kwenziwa nalesi sivumelwano ebekade siyenziwe lesiyana ngommangalelo wesibini la bekade ethe angavuma icala bese yena kugcina seyikuthi ugcina sekufakazi. Kodwa akusukuthi umuntu mayeqeda ukugunyuluka bese uthweswa amacala.
What do you understand about the procedure after you have explained the rights of the accused to be brought before court within 48 hours? What do you understand by that?
My understanding, my lord, is that when he's charged, my lord, he must indeed appear before court within 48 hours, and if 48 hours lapses on the weekend, on the first day of the court appearance, when he's charged on that matter, not when he's given rights for investigation purposes. Those are two different things, my lord. You are given rights, 14A, you are charged formally to say, now, these are the charges, we're putting them on you. Then indeed, within 48 hours, or on the first day after the ending of the 48 hours, if it's on weekend, my lord, the said person must appear in court.
Engikuzwisisisayo ngokuthweswa kwamacala ukuthi umuntu ma ethweswe icala lo muntu loyo kwamele ayobingelela umantshi kumahora kungakapheli amahora ayishumi nesishiyagalombili. Uma kungenzeka ukuthi lawo mahora lawo awela ngaphansi kwempela sonto kulayi ukuthi lo muntu loyo iviki uma iqala kwamele ayobingelela umantshi. Kodwa uma ingabe kungayenzakalanga kanjalo mhlawumbe ingakathweswa amacala kungenzeka ukuthi amahora lawo amahle adlule.
All right. Accused number 1 was detained in Valeria after the taking of the confession. He was detained.
I agree.
And his rights were explained further.
I agree, but the reason, my lord, that's what Mr. Ngomizelo is not going to. He was detained in Valeria for the charge of dealing in drugs. And the rights were given insofar as that matter. Subsequently, he was formally charged, and on the 1st of June, he appeared in Tembisa court for those charges.
uthi ke
2020, 1st of June 2020, my lord.
umangalelwa wokuqala ke yena ngemva kokuthi sekakhulumile nalo yelela phoyisa uye waboshwa ke wavalelwa eValeria. Uthi yebo wavalelwa eValeria kodwa bekangavalelwa ngenxa yaleli cala ukuthi ulithweswe lona noma bekade ebhekene nalo. Ubekade evalelwe ngenxa yaleli yacala lokushushumbisa idakamizwa akusiyileli esikulo namuhla.
Yes. Now the question is, from the day he made a confession, the alleged confession, that is the 30th of May. Then the 6th of June, it's an alleged pointing out. So, was that evidence not enough to charge accused number 1?
So, my lord, let me just correct one thing. The pointing out was done on the 5th of June, not the 6th.
Sorry, the 5th.
Yeah, the 5th of
Yes.
June 2020, my lord. That's the first part.
Yes.
Now, yes, my lord. So, in the confession, the written confession, not the pointing out, certain things were said by accused number 1, which one followed extensively. And what we followed is in the docket that we disclosed to the defense. As I said, we needed to corroborate what was said there. So there were things that were said there that were followed in terms of his co-accused and where possibly the whole thing came from, the killing of Senzo Meyiwa, because he mentions clearly who gives them the instruction to kill Senzo Meyiwa. So those things, you can't just say now it's enough. You've not found independent corroborating evidence of the assertion that he's saying.
Manje ke umangalelwa yena uyaboshwa ke nge-30 zika May 2020 bese nge-5 kulayi ukuthi yena uyahamba uyokhomba okuthize. Uthi yebo ke kodwa bekwamele siphenye siqhubeke uphenyo ngoba kunezinye izinto azishoyo kuleya ndaba le ayikhulumile. Uyasho nokuthi ubani obatshelile ukuthi bayobulaya uSenzo Meyiwa. Bekungasi ukuthi sizovele sithathe lokho akushilo bese simthwesa amacala. Bekwamele siqale siphenye.
All right. If a person is detained after he has made a confession, and on the 5th of June, it is alleged that he pointed out either the crime scene or whatever place, that person is still kept in detention until he is charged on the 26th of October 2020.
My lord, he was kept in detention not for this matter. He was in detention for the drug dealing matter, not this matter.
Umangalelwa lo njengoba eboshwa nge-30 zikaMeyi nge-5 ehamba ayokhomba le ndawo noma eyokhomba noma yini le bekade yenzeka, uye wagcinwa estokisini kufikela nge-26 zika October 2020. Uthi yebo kodwa engagcinelwanga leli cala, wayekade egcinelwe icala leyidakamizwa.
But the investigations were ongoing whilst he was in custody.
I agree. So far as this matter is concerned, they were ongoing, my lord, and rightfully so.
Yebo uphenyo lalikade liqhubeka ngaleli cala njengoba umangalelwa yena wayekade egcinwe estokisini.
Okay. So, to place it on record, from the day he made such an alleged confession, pointing out on the 5th, up to the day in which he was formally charged on the 26th. Accused number 1 indicated to me that there is a document where his fingerprints were taken, and that document bears the date in which he was charged.
I'm not sure, my lord, what document is referring to. But what I can say about fingerprints, the taking of fingerprint does not necessarily mean you have been formally charged. Fingerprints are taken, for example, if you want to run your fingerprints to see if you are linked in other matters, which, for example, it could be circulated or partial prints, appearing on the system and you are still outstanding. So there are various reasons why fingerprints are taken, but I'm not sure what document is referring to in this one in particular. But all that I'm saying is that during the cold case analysis, as I've indicated earlier, when we were trying to triangulate them and eventually go to them, a lot of extensive investigation in terms of profiling, and obviously when we got to them, prints were taken for the Tembisa matter, and obviously elimination prints were also taken to see if you can pick them up in various matters. Hence, different cases were picked up that we were aware of before we picked them up. Others came up after accused one was picked up, my lord.
Manje ke umangalelwa utshele ummeli wakhe ukuthi kunephepha thizeni eyukuthi lela setshenziswa ama fingerprint wakhe wabekwa kulo lelo phepha. Uyalazi na uthi ufakazi uma yephendula ucha lelo phepha ngazi ukuthi eliphi. Mina ongwaziyo ukuthi umuntu akusukuthi makuthathwe ama fingerprints wakhe lo muntu sekathweswe amacala. Kungenzeka ukuthi lawo ma fingerprint athathwa ukuthi kuyohlolwa ukuthi mhlawumbe awekho amanye amacala la ukuthi lo muntu ubandakanyeka kuwo noma lo muntu loyo. And my lord, I see the accused has raising his hand.
Yes.
Lo muntu loyo angahle mhlawumbe ama fingerprint lawo kuyohlolwa ukuthi akhona na amanye amacala noma lawo ma fingerprint kugcine seyukuthi usayobhekwa ukuthi lo muntu lo uyena lo muntu osithi uyena.
All right. Tell me, who formally charged accused number one?
It's Sergeant Mahula.
Ubani umuntu othwese umangalo loqala icala uthi uSergeant Mahula
In relation to this matter,
Yes,
of Senzo Meyiwa.
correct. In relation to Phosphorus 636 of 10/2014, my lord.
uthi ngikhuluma ngayo uSergeant Mahula uyena othwese umangalo loqala icala leli lika Mufi uSenzo Meyiwa.
Do you know which date was he charged?
26th of October 2020, my lord.
Uyazi ukuthi uthweswe nini icala uthi yebo bekade kuyi 26 zika October
Next.
2020.
Thank you, my lord. According to evidence or the version of accused number one, he says you're the one who charged him at Phosphorus police station, and it was, he can't recall the date, but it was in August.
My lord, as I've said, I mean, we've disclosed the docket. The 14A, the defense is in possession of. They can see the person who gave the notice of rights insofar as this matter is clearly depicted. There's no confusion. It's Sergeant Mohola. The statement that she's made insofar as charging the accused on the 26th of October, it's there. The defense has it. The warrant of arrest that was executed on the 26th of October 2020 is also there. It's been disclosed to the defense. There's no dispute who charged him. It wasn't me. I did charge some of the accused, or one of the accused, but definitely not accused number one, my lord.
Sibiya uyalichitha ubrigadier Dininda udaba lokuthi uyena okuthwese icala ngo-August uthi cha akusuyena. Yonke into ibhaliwe edocketini futhi uthi ibhalwe ukuthi uSergeant Mahula uthi yebo yena ukhona omunye wenu oyikuthi uye wamthwesa amacala kodwa bekungasusibi.
My lord, with your leave, may I reserve this question until I fully consult with the contents of the docket
You haven't consulted the docket
relating
yet.
to relating to that aspect. I need to revisit my notes. The docket.
Okay, fine.
So in essence, my lord, what I can say, my lord, there is no reason for me to hide the fact that I would have charged accused number 1 if I did. Hence, the accused that I charged, that is before court, and that is accused number 4. My statement is there as well. Notice of right, statement, the warrant that was executed is also attached in the docket, and it has been disclosed to the defense. So there's no hide and seek around it. It's the pertinent issue, my lord. I don't think it's really something that we want to hide, my lord.
Now,
uma egcwalisela kwimpendulo yakhe ke ubrigadier uthi asikho isizathu esingayenza ukuthi yena afihle ukuthi uthwese bani amacala, uthi kahle kahle umuntu oyena amthwese icala umangalelwa wesine oyikuthi uyena oyewamthwesa amacala, akusumangalelo wokuqala. Asikho isizathu esingayenza ukuthi yena afihle ngoba into encane ukuthi ukuthwese umuntu icala bese uyayichaza, akusinto ukuthi angahla ifihle.
if permission is granted, my lord, may I proceed to other questions?
Yeah, no.
Yes. There's one thing that I just want to conclude on the aspect of the taking of the, it's an obvious question. It's an obvious question that you were not present to prove that accused number 1 gave that confession freely and voluntarily. When he was, the allegation that he made such a confession, you were not physically present.
With Colonel Mboto, which accused perhaps, maybe to be
I
more
was
specific.
referring to accused number 1.
I was not with Colonel Mboto, I agree. I was not there. But if you say to me, my lord, the confession was not made free and voluntary, that's not the impression I got, because it started with me. And my understanding, it was free and voluntary. When he came back, I spoke to him, and I didn't receive any complaints from him. Hence, the proceedings of the pointing out to the traditional healer the following day was embarked upon. The arrangement of the formal pointing out, confession by conduct of the 5th of June was embarked upon after I've confirmed with him in person on the 4th, the day before, that he's still willing to proceed with this confession by conduct. So the information or the impression that I got in all material times, because he was warned according to his constitutional rights, is that he was willing to continue and he was making these confessions freely and voluntarily. I don't have any reason to
Uthi-ke manje kuyazeka ukuthi wawukade ungekho ngalesikhathi ummangalelo wokuqala egumuluka, uthi yebo bengekho, kodwa mina into engiyaziyo ukuthi ukhulumile ekhuluma engaphoqwanga ngoba uma ebuyela kimi ngiye ngambuza ukuthi uhambe kanjani laphayana, ukhulume kahle, akuzange kube nokuthi aphoqwe, akazange alinyazwe noma into ezinjalo. Uthi umangalelwa naye akazange angibonise noma angitshele ukuthi ushayiwe noma kunani eyenzakele ebekade ingekho emthethweni. Uthi futhi leyo into ukuthi ngijwayele ukuthi ngiyenze ukuthi umuntu uma ebuya bese ngiyambuza ukuze nganeliseke nami ukuthi lo muntu akaphoqwa.
You deal with the requirements of freely and voluntariness in sound and sober senses. On the interview that you had with the accused, that was not a confession, in terms of the provisions of Section 217. It was just an interaction between you and the suspect. So there were no formalities there. But the formalities, in terms of the provision, must be proved by the person who took a confession. When you say, may I just qualify this for you to understand this, you explain the rights. After you said they said information to you, that was an informal process. Do you agree?
I'm not sure.
May I repeat it?
Yeah.
May I rephrase it? At Fosloras police station on the 30th of May, when you were interacting with accused number 1, I'm saying whatever that he said to you was an informal process, because for you to legitimize that process, you had to get somebody who must take a formal confession. You agree?
I agree. I agree, my lord. But the part that I wanted to correct was that it was the rights before and then he spoke, not the other way around. That he spoke and then I warned him.
Uthi manje ke uyavuma nawo ukuthi inkulumo yakho nommangalelo wokuqala lapha eFosloras bakade kuyinkulumo nje ebungasi inkulumo esemthethweni noma ebhalwayo ukuthi ingahle isetshenzisiwe. Uthi yebo lokho ngiyakuvuma, kodwa ngicela ukucacisa la ukuthi akusukuthi ukukhulumile bese ngimtshela amalungelo, ngimtshele amalungelo cala bese uyakhuluma.
Yes. What I want to put across to you is that what Mboto or Colonel Mboto has done with accused number 1, and you were not present, cannot be an evidence by you to confirm that the provisions of section 217 were complied with. That from you is a hearsay evidence,
Well,
because
my
you were
lord,
not present.
Yes, I totally agree, my lord. I was not there. All I'm saying, and that's what I've said even earlier, I'm not giving an impression that I was present. All I'm saying is that prior to Colonel Mboto kicking in, I was convinced that he's prepared to make this confession freely and voluntarily. And the issues of not being under influence, my lord, I think they're critical, because you cannot, for example, establish that the person is under medication or he is intoxicated. I mean, why would you want to formalize that confession? So they were important before you can start formalizing the process. But yes, I was not present with Colonel Mboto. All I was saying is that there was no reason given to me prior to the taking of the formal confession and after. But furthermore, my lord, I had access to the confession when I collected it from Colonel Mboto in his office. And it's clearly, I mean, I read it, I read it, I saw what questions were put, what answers were given, and the signatures that were put there. So if you go through that confession, insofar as I went through it, my lord, I did not also get any impression that some rights were violated, insofar as the performance is concerned.
Mina ke ngibone ukuthi ngemva kokuthi umangalelwa aye kuKolonel Mboto ekhulumile mase sekufika leliya phepha ukuthi bekade elibhala, ngibone ukuthi akunamalungelo wakamangalelwa ukuthi wona ayiwanyathelwa la ukuthi umangalelwa mhlawumbe wenziswe into bekade engafuni ukuyenza, ngoba njengophoyisa eliphenya kuyicala ngiyengafunda konke obekade kukhulunywa kubhalwa ngabona nemibuzo ebekade ibuzwa. Futhi kubalekile ukuthi umuntu umbheke noma umbuze ukuthi lento afuna uyikhuluma ngenhliziyo yakhe ekhululekile akaphoqwanga, uthi nalokho ngikwenzile njengoba ngiyiphoyisa eliphenya kuleli cala.
The essence of this question, before I move on to something else, is that the version of accused number 1 says he was compelled to endorse a signature on a statement. He did not make a statement himself. And that when he endorsed the signature, you were not present.
Yes, I agree, my lord. Like I've said, what took place insofar as the formal taking of the statement, I was not there. So Colonel Mboto, I think, will be a better person to talk to those issues.
Uthi umangalelwa wokuqala uma etshela ummeli wakhe ukuthi yena uye waphoqwa ukuthi asayinde iphepha elithize eline statement, futhi wena brigadier wawukade ungekho, angisho uthi yebo engikade ngingekho, nalokho uKolonel Mboto ongeza ezochaza kabanzi ngalolu daba umangalelwa okhuluma ngalo.
And in relation to the issue of being kept incommunicado, he was not afforded an opportunity to communicate with his family. he was kept in a single cell alone. Will you regard that as human enough to detain such a person under those conditions?
So, my lord, I think I also dealt with this aspect last year, in that during June 2020, the country was under COVID lockdown. It was a regulation which, if you violate, you could be charged to maintain a safe, distance between parties. And I did mention, my lord, that depending on the facilities that each police station will have, they will decide as to how many inmates they will incarcerate per cell. We, as the investigation team, did not have influence, detection as to who must be incarcerated where. Ours is to hand the person in, sign the handing over of that person, they receive that person, they place that person according to the category of the charges he's facing, and as they deem fit according to their regulation. That is the first part, my lord. But the second part, which says he did not speak to his family, I don't think it's true, because on the first appearance in Tembisa, he was legally represented by legal aid. Subsequent to that, his family hired a private attorney who represented him in that matter and eventually came to Phosphorus when we charged him in Phosphorus court. So he was able to make those calls and communicate with his family, and hence private attorneys were activated.
Ummeli uchaza lelo daba lokuthi wena Sibiya uye wavalelwa ngendlela ebekade ingekho emthethweni la ukuthi awuzange unikwe nethuba lokuthi uxhumane nomndeni wakho futhi wawukade uvalelwe wedwa. Uyachaza ubrigadier ukuthi yebo ekuvalelweni yedwa bekungasithina abaphenyayo ngecala abatshele ipolice station ukuthi lo muntu akavalele yedwa. Uthi uma sikhumbula ngo-2020 ngoJune country yonke yayikade ikwi-lockdown la ukuthi abantu bekade bengamelanga ukuthi bagcwale la ukuthi ipolice station yona iyona ebekade isho ukuthi kwamele kufakwe abantu abangakanani eselini elithize. Futhi lolu daba lokuthi wena bowungaxhumani nomndeni wakho uthi akaliboni kuyiqiniso ngoba uma uyovela phambi kwamantshi uye ubokade unommeli we-legal aid la ukuthi ngemva kwalokho wena umndeni wakho uyibekade ukhona futhi wakufunela nomunye ummeli okhokhelwayo, yingakho bona babona ukuthi wawukade uxhumana nommeli wakho njengoba wawukade uxhumana nomndeni wakho njengoba wawukade ukhona futhi bakufunela nommeli okhokhelwayo.
My lord, I'm not sure if it's convenient time to attend for lunch.
Yeah, you said you wanted to, pose some other questions.
It's only one question, the aspect.
No, we can do it any other time.
Yes,
Okay, so, but you want us to adjourn now?
for lunch.
Is that the consensus, Mr. Baloyi?
Indeed, my lord, it's
Okay.
time for the long agenda.
There's just one aspect this court is going to remark on. He keeps telling Mr. Mgumezulu that when I so-called interfering, I only quoting the law. You see this process of saying when he agrees with you, you're both wrong. When you put it to him, Brigadier Gininda, that when you were speaking to your client, accused number one, and gleaned from number one that he wants to make a confession, that was an informal process. No, that's a constitutional process. It's not informal. Our law says an accused person must be apprised of his rights in terms of Section 35. So when this accused person, who is a lay person and doesn't know the law, says to you, when you speak to him, he wants to make a confession. When you engage him, that is his constitutional right, and that is a constitutional process. Okay,
May I tell?
that's the law.
Yes.
You and Gininda can agree on another law. That one I don't know.
My lord, may I clarify it? The explanation of rights is something else.
No, fine.
I was talking about,
An informal process.
Yes, like taking off a confession in terms of section 217.
It's not informal, Mr. It's not. It's a constitutional requirement that before a person makes a confession, he must be apprised of his right. Can I ask Mr. Am I correct? Mr. Niso?
There's nothing informal.
Yes. You see, and I keep quiet now. Hayi, le judge has umthetho. When I mention it, hayi, le judge interfere.
manje-ke inkantolo ichaza ukuthi njengoba ummeli ethe ngalesikhathi ukhulumisana no-brigadier leyo nto yakade inkulumo engekho emthethweni, uthi cha inkulumo esemthethweni ngoba umthetho-sekelo i-constitution iyachaza ukuthi umuntu uma efuna ukukhuluma leyo nto leyo ayikhulumayo ilungelo lakhe eyikuthi lisemthethweni. Manje ngalesikhathi nikhuluma no-brigadier bakade kuyilungelo lakho eyikuthi lisemthethweni futhi libhalwe nakumthetho-sekelo. Inkosi yenkantolo ithi yona ayigamukeli kule indaba ezikammeli wakho no-brigadier Gininda, futhi uyabuza nomnumzana uMnisi ukuthi iqiniso na uthi yebo into esemthethweni ngoba ilungelo elikumthetho-sekelo.
Okay, can you adjourn then until 2?
Bad idea. Hello, ladies. Yes, up. Yes. Guys. What the which channel? SABC, which one is 4? Yeah? Which one is 4? Which one is 4? I get the SABC, the Oh, is it? Yeah?
Yeah, but sorry. To be fair to Mr. Mgomezulu, what do you want from this docket so that this court must assist you to have access to it if it pertains to the defense of your client about the admissibility or otherwise of the alleged confession the state alleges that your client made? Are you with me?
I'm with you, my lord.
Yeah, so that you can peruse it.
So before, my lord, I can answer on that. May I ask one question from him, then I'll take it from there.
Okay.
Are there any persons mentioned in the docket who appeared in court?
There's two names here, my lord. It's Teliselani Buthelezi on top, and then number 2 is Ntanzi. Its surname is Ntanzi Bongane Sandile, which is accused number 2.
Kunabantu na ekukhulunywe ngabo kulelo dokodo uthi yebo babini kunoqiniselani qiniselani Buthelezi omunye ke bese kuba uyena uNtanzi.
Okay. Do you have the copy of the charge sheet?
No, I don't.
Uthi akanayo ikhophi yale yancwadi ebekade ummangalelwa ethweswe amacala ngayo.
You said the matter is not finalized yet.
Yes, Sergeant Mokhane is still investigating the first. The matter is still, Sergeant Mokhane is still investigating all this.
Alikaqedwa lelicala laseNongoma njengoba ukuthi uSergeant Mokhane yena usaphenya ngalo.
Sergeant Khane, was he the only one who was investigating on that matter?
It was assigned to him. Ever since the matter got to us, my lord, it was assigned to him. But as I said, in KZN, a certain defense investigating officer who was pursuing the first suspect at that time was the investigating officer. But this side, ever since it came, it's Sergeant Mokhane, my lord.
Manje kuyabuzwa ukuthi uyena yedwa na uSergeant Mokhane oyikuthi uphenya lelicala kuthiwa lani kwayena soloku lafika la kithi kodwa eKZN ukhona omunye oyikuthi naye ubekade ephenya kakhulukazi indaba le kamangalelwa wokuqala kuleli cala.
Waiting for the
Yeah,
instruction.
fine.
I remember there was evidence by Mr. Sergeant Mokhane to say he the instruction is that in that docket there were 2 accused persons, namely Thabani Ngwenya and Qiniselani Buthelezi. And that matter was finalized. Do you have something to say?
My lord, I agree. The matter in KZN was finalized. The investigation insofar as accused to is not finalized. And this is what Sergeant Mokhane was basically about.
Uthi ke ummeli yena utshelwa ukuthi kuleli cala lakwaNongoma bekade kunamamangalelwa ababini Thabani Ngwenya noqiniselani Buthelezi eyikuthi lelo cala lelo laqulwa uthi ke ubrigadier yebo kakade kunabamangalelwa ababini uphenyo lwaphela.
All right.
With the conviction for Mr. Buthelezi, my lord. Buthelezi is the individual that I said we have approached based on the collaboration of the confession that we got from accused number 1. And the statement for this Buthelezi is in this docket 636 and has been disclosed to the defense. That is the accused that is charging Mr. Buthelezi.
Buthelezi loyo okukhulunywa ngaye kuleli cala uye wayiwa kuye futhi wenze istatement leso statement leso sikhona kwidokodo leli lika 636 ileli elalecala leli esilikhulumayo namuhla uthi futhi leso statement sanikwa nabameli.
All right. let's just put things into practical perspective. A matter was finalized and the verdict, was it a guilty verdict?
Yes, for Mr. Buthelezi, it was a guilty verdict with a direct imprisonment.
Manje uthini uthi lelo cala laqulwa kwaba nesinqumo kwaba nesahlulelo uthi yebo uButhelezi watholwa enecala futhi wathunyelwa ejele.
What happened to the murder charge in respect of Buthelezi?
There's a guilty verdict, my lord. I didn't, as I said, I signed this matter to the IO. I'm simply talking, you know, the cosmetic part, but obviously there was a finding, and it's a guilty verdict with a direct imprisonment.
Yeah, but it's for murder.
I think it is for murder because the sentence, it's my lord, I don't want to perhaps say the wrong thing. One will have to go and maybe get the sentence so that I don't say what is.
But it should be annotated on the docket. Isn't it?
No, it's not written, my lord.
It's on the other one.
Yes. It's
Where
on
is the
other.
other one? That is the one of Nongoma, which is allegedly finalized.
What we have in there, my lord, it's what was in the docket of Nongoma, because subsequent to the adjournment, I even made arrangement that we speak to the IO, and what we have, because we wanted to see those issues of the sentencing that would have occurred when we are here. There's nothing that they have except this. What I know that is available is the sentence, which is on the system that we can draw, and then we can make it available, my lord.
It will say sentence for murder, guilty of murder, sentenced to such and such a period.
Correct, my lord, that's what it will say. Or whatever charge they've convicted them on.
Yeah,
that,
fine,
that we can get, my lord.
So this matter is coming from 2018.
That's correct, my lord.
Manje ke kulo lelicala laseNongoma uthini uthe kunesigwebo esakhishwa futhi bekade kuyisigwebo na sokubulala uthi yebo kwakhishwa isigwebo kodwa angifuni ukuthi okwamanje ngisho ukuthi bekulo muntu wagwetshwa iminyaka emingaki ngoba nginaso isiqiniseko kodwa kwisystem isikhona singakwazi ukuthi sisidonse bese sikwazi ukutshela inkantolo ukuthi lo muntu wagwetshwa iminyaka emingaki futhi ke uma eqhubeka ubaba uButhelezi ubaba uMngomezulu uma ubuza futhi nokuthi lo muntu loyo yena ngempela ugwetshiwe uthi yebo ugwetshiwe kuleli cala laseNongoma.
From the 19th of June 2020, I can see this matter is coming from 2018. Accused is arrested on the 16th of June 2020. On the 19th, the matter is removed from the roll. What steps was taken after the 19th to secure the attendance of accused number 2 to Nongoma court?
My lord, so as I've said, the IO was Sergeant Mohande, but then secondly, on the 19th, then the case of possession of unlicensed ammunition kicked in. That's the first part, which was in the Northwest Province. Now, if one had to, and I'm not talking in defense of Sergeant Mohande, but if one had now to pursue this, my lord, in terms of placing it, investigations were conducted collectively. They didn't stop. But if one had to singly focus on this case, it would have meant that the accused would have been placed in KZN. Then he would have had to move from KZN to Northwest and subsequently to Gauteng, which was a risk factor. So the approach was that all these matters, when we now had him on the Bokeng matter, must be investigated, completed, presented to the DPP, so that as and when the decision is taken, collectively the centralization point is made to avoid risk factor and the cost factor, because we would have had this matter, the Northwest matter, there's another matter of Rustenburg where the details were disclosed to the court, then KZN. It would have been a mess, my lord. We knew where the accused was, he was in custody, so the view was that Sergeant, investigate, complete everything, let's have it centralized, presented to the DP and get a central point where all these matters will appear.
Manje ke leli cala leli kube siye sathatha icala ngecala bekuzofuneka ukuthi ummangalelwa agcine seyikuthi uyovela enkantolo kwaNongoma avele ePhukeni abuye azovela futhi nala eGauteng la ukuthi lokho bekade kuzoba into eyikuthi bezosifaka esimeni esibucayi ngoba bekwamele simsuse kuzo zonke le indawo ingakho siyesanika usajeni umsebenzi wokuthi akaye ayophenya wonke lamacala ukuthi uma sesesiwanika kumphathi wabashushisi akwazi ukuthatha isinqumo bese sikwazi ukuthi simbeke endaweni ebekade izovumela ukuthi zonke lezi indawo zibe eduze noma akwazi ukufinyeleleka ummangaleli.
Okay, I'll get into the particulars of the accused person and the verdict thereof. My concern is, we knew that accused number 2, since he was arrested on the 16th of June, this year is 2024, accused person has never appeared in that court under the case number.
It was not enrolled, my lord. Like I said, it was never enrolled, we agree. But people are placed when the matter is accepted by NPA. And you place them, then you can transfer them. So it was not enrolled. That's my understanding.
Objection, my lord.
Yes.
My lord, there is evidence that was led in this court regarding this docket. There is, I'll double check the number of the exhibit, my lord. It was a printout, computer printout of this docket, reflecting another information. And then today, my lord, the evidence or reference is being made to the same docket. And the witness is testifying on the content of this document, which is in front of the witness. My lord, as a result of that, I submit that as the defense were entitled to the disclosure of the docket in which the witness is making reference to. And even in the evidence of Sergeant Mohane, my lord, if I'm not mistaken, reference as to this, regarding this docket, was made that was the basis for the arrest of accused number 2. As a result of that, my lord, I submit and I ask with the leave of the court that this docket should be disclosed to the defense so that we can be able to verify what the witness is testifying about right now.
Yeah, I said so. I said, to be fair to Mr. Mngomezulu, if this docket or his instructions are that there is a link, this docket can be utilized for the defense of his clients in the trial, within the trial.
Yes.
This court can authorize that you must have access to the dockets,
Yes.
so that the defense of your clients is not impinged upon. That's what I said.
Thank you, my lord. I'm asking for that permission, my lord. That's the court business, my lord.
Mr. Baloyi, what said you?
Yes.
Please note, I had a quick look at Exhibit WW. It contains the list of those confidential cases that Sergeant Mohane requested.
Yeah,
that they
it was
should not be
disclosed that
disclosed.
confidential cases, you remember?
Yes, but this docket doesn't feature, on that list. I think it's something we can sort out between
There are 4 dockets, Mr.
ourselves and the defense.
Yes,
Yes, ma'am.
there are 4 dockets.
Yes, ma'am.
Give them to these witness, to the counsels here.
That's the court business, my lord.
And go and show these dockets to your clients, like what happened with the confidential information, which I said it's only for the eyes of the defense and the court.
That's the court business, my lord. We want.
So you want us to adjourn and you want to see them,
That's the
or
court.
you want to do what?
We're asking for the adjournment, my lord, because the witness is continuing to go deep on this docket. So
Okay.
we need to have it before it continues.
Okay, fine, Mr. Baloyi.
As a court, please, my lord. My suggestion would be perhaps if Advocate Mngomezulu wants to canvass other issues, this matter can always be canvassed tomorrow, where we can
Okay,
continue.
you are fine. Any other issue you want to canvass with this witness, Mr. Mngomezulu?
Yes, I think we should ventilate on this aspect first.
Which one? First?
Yes,
On the docket aspect first.
Yes.
Okay. So they must read the docket here in court. They don't go with it to my house.
Ummeli uyacela ukuthi lamadokodo lawa ubrigadier akhuluma ngawo bawabone. Inkosi yenkantolo ithi yebo lokho kuyavumeleka. Enye into esemqoka inkosi yenkantolo ivezile ukuthi abameli banganibonisi lamadokodo njengaleli yaphepha ekuthi liye lavezwa nyakenye leli kwachazwa ngalo manje ke inkosi yenkantolo ithi bawabheke lamadokodo manje la bangahambi nawo emakhaya.
Okay. You're available tomorrow?
Yes, I am, my lord.
Okay, let's adjourn now. What's the time now?
It's 14:30.
Yeah, so that you can take instructions if you glean any information which affects the defense of your clients in the trial within the trial.
Thank you.
Okay, so we adjourn for the perusal of the 4 dockets by the council.
Sigcina la namhlanje ukuthi abameli bayobona lamadokodo sizobuya futhi kusasa.
Okay.